All right, Happy New Year. This is the recording of week 8. You'll see that we're looking at extrinsic material, and the focus is on the how we understand the common law approaches to using extrinsic material. Also the statutory provisions which allow for extrinsic material to be used in the interpretation of legislation, and we critically analyse the different approaches to interpretation using extrinsic materials. What you'll find when you look at this part of the course is that it is very much a rework, if you like, a re-examination of some of the things we've been looking at before in the earlier topics. Extrinsic, we mean things outside the statute which we take into consideration. And you will recall these from weeks in the past. That is parliamentary Hansard, different parliamentary reports, maybe a report of a parliamentary committee, agreements or conventions or treaties that were the basis for the enactment in question, comments by the relevant minister, potentially in a press release, in Parliament, in some type of document relating to the Act, explanatory memoranda that issued by the department relative to the Act, and of course things like dictionaries and case law where judges have interpreted the meaning of specific acts. The key terms will obviously extrinsic being outside of the text of the Act, and the focus there traditionally has always been on the second reading speeches by the relevant minister in the Parliament, and of course to some extent where the relevant minister might answer questions about the relevant enactment or amendment to the enactment in the Parliament, explanatory notes and dictionaries. Intrinsic is obviously what we've looked at in the past, that is things within the Act, the objects clause, the purpose of the Act as defined within the Act, definitions within the Act, the different parts or chapters, etc., in the Act and the relevant section itself. We've been looking at intrinsic material, but of course in the past we've also looked at extrinsic material as well, when we've been looking at the different mechanisms and approaches and practical ways of statutory interpretation. So let's have a look a bit further though at extrinsic material. The Commonwealth Acts Interpretation Act in section 15AB, and you can see by that section number that it's been added in later into the original legislation, which is in chapter 5. When we look at that section, we see that it provides authority to the courts to consider the purpose or object of the Act, section 15AA. Most of the states, and Queensland is certainly one of them, have a very similar purpose type provision in their legislation. So there's 15AB in the Commonwealth Act. And if you look at it, it's subject to the subsection. We have to interpret the provision of an act by ascertainment of the meaning of the provision, and to determine that, we look very much at the purpose of the Act. The first part of 15AB does need some further consideration, but what it really allows us to do is to consider material which is extrinsic to the Act itself. So when you look at 15AB, you see it has two parts. The first part says, focus upon the ordinary meaning of a section. What does the section actually mean when you just read it? Secondly, if you can't work out what the section means on its ordinary meaning, because there's some uncertainty, some ambiguity, some obscurity, something that's unusual that comes out of the ordinary meaning, something unreasonable, then you need to look extrinsically, or you need to identify and determine what that meaning is. And to do that, you obviously have to go to some other place extrinsic to the act. It says here, you might recall that Justice Kirby says, well, it would be very rare that there would be some type of ambiguity. And they mention here another quote from Justice Madgwick in a case called Parrott and the Secretary of the Department of Family and Community Services. So that's the Commonwealth Department, as it then was, of Family and Community Services. So you can see it's an older case, 2002, volume 124 of the Federal Court Reports, 299 at paragraph 32 when it's in those square brackets. There, Justice Madgwick said that it seemed to be a sensible approach to acknowledge that it was still possible to determine that the ordinary meaning may not be confirmed. So what he's saying is, look, there might be occasions when the ordinary meaning may not be clear and you need to go beyond the act itself and look extrinsically. So, and that's exactly what he did in that case. He went to the extraneous, the extrinsic material, and came to the conclusion that the ordinary meaning was not the correct meaning. You can see that Parliament want us to focus on the words in an act, but there'll always be, and that's what these different judges have been saying, Justice Kirby, Justice Madgwick, there will always be some specific factual circumstance where the ordinary meaning may not be appropriate because it cannot be what Parliament intended when they wrote down this set of words. It shows the fragility, if we call it, the fact that the English language is quite fragile when we interpret the meaning of specific words. In section 15AB, there's the use of the word may. And what they're saying there is a discretion. Judges are not required to consider extrinsic material if they do not wish to exercise their discretion to do so. They may look at that extrinsic material, or they can just rely upon the ordinary and plain meaning of the words in the section. And the notes then refer back to your textbook where there's a case, a 1990 High Court case, Mills and Meeking, 1990, volume 169 of the Commonwealth Law Reports, which is the High Court authorised reports, commencing at page 214. And there the Chief Justice Mason and Justice Toohey said the language was not ambiguous or uncertain, and consequently the two judges refused to exercise their discretion to look at the extrinsic material, to go beyond the plain meaning, the literal meaning of the words in question. Context and purpose is the next heading. Obviously, it's very important to consider legislation in a specific context. There's been some significant legislation in Queensland in the last 6 to 8 months, and there was a societal or a political context that could be said to be directly relevant, and in fact part of the ministers, or the minister or the ministers, the Premier and the ministers, have placed that legislation in that context and said, well, this legislation is being passed because of the context in question. So it's important sometimes to consider that context. They mention here the case of CIC Insurance Limited and the Bankstown Football Club. Once again, 1997, 187, volume 187 of the Commonwealth Law Reports at 384. In that case, the court, that is the High Court, maintained that the modern approach to statutory interpretation required examination of the context in the first instance, not just whether there was some ambiguity. So that's a different approach to what we're seeing in section 15AB. And if you were going to rely upon that case in saying, well, look, we need to go to the extrinsic material first, even when there is an ambiguity, you need to be very careful. And one of the things you need to do is to check in a specific factual situation that you might be confronting whether the statute in question that's applicable to you, let's say if it's the Queensland statute, whether that statute allowed you to do that, and whether you're breaching or contradicting the words of the statute that's telling you how to interpret the legislation. And you can see in this Brofo in the Western Australia, the High Court again sort of said context and purpose is very important. So what's this common law approach? So when we talk about common law, sometimes common law can have different meanings. Common law can be the law of England as opposed to the law of the continent, the law of France or Germany, which we call sometimes civil law. Common law can be the law made by judges as opposed to statutory law or legislative enactments made by Parliament. And sometimes common law can just be common law as opposed to statutory law in the sense of the broad brush idea of common law being all of the law that exists within our system of law. So I said common law as opposed to statutory law, but common law really as a definition for all of our laws within a place, such as Queensland or Australia, the common law of Australia or the common law of Queensland. So you can see common law has a number of different meanings. When we're talking about common law here, in this context, we're talking about common law being the law made by judges. The common law, how judges approach extrinsic material. So one of the things judges they'll have to do is they have to follow what Parliament has told them to do in terms of the statutory way that they must interpret material. And the Acts Interpretation Act tells the judges how they are to interpret legislation. But it's not a code, and by code we mean a specific mechanism that must be followed. As we were saying before, must as opposed to may. May giving the judges some discretion in the way that they actually do things. So the common law approach to the use of extrinsic material is not something which is you can easily determine straight away. It's something that requires a careful consideration. The first example I give here is a High Court case called Catlow and the Accident Compensation Commission, 1989, volume 167, Commonwealth Law Reports at 543. There, Justices Brennan and Gaudron said that it would be erroneous to look at the extrinsic material before exhausting the application of the ordinary rules of statutory construction. Now, this is what I was saying before. You need to be very careful with some of these older, when I say older, cases from, say, 20 plus years ago, or even cases from the 1990s, because, of course, some of the statutory provisions have been changed to tighten up and to clarify the way some of this interpretation stuff must be done by the judges. The textbook, though, provides this mechanism, or this suggested approach, they call it. The first step is to work out the meaning attributed to the statute, see if that meaning is consistent with the text of the section. If the meaning of the text is plain, the extrinsic material cannot alter it. But if the meaning of the text is doubtful, so if there is some ambiguity, look at the extrinsic material. And that's what we were saying before. So what extrinsic material can we rely on? So, for example, if you were to write an article about what you thought a section meant, and that article was to be published, is that article something we could rely upon? Or is it only statements made by a minister, for example? Here is subsection 2 from the Commonwealth Acts Interpretation Act. And it sets out, you'll see, the sorts of things that we could rely upon. A relevant report of a Royal Commission, a Law Reform Commission, a committee of inquiry or other body that was put before the House and the Parliament, report of the Parliament, explanatory memorandum, treaty or other international agreement, a speech made to the House of Parliament by a minister. Any document that is declared by the Act to be a relevant document. Any relevant materials in the journals of the Senate and the votes and proceedings of the House of Representatives. So we're getting an articulation in the Acts Interpretation Act of the things that Parliament has, that the legislature are telling us are things that we can consider as part of the process. You'll see that the list is long, but it is also not exhaustive. That is, there are other things that could be potentially relevant. And the other thing I think which is stated here is that there isn't a hierarchy. You don't place one thing in ranking to the others. You don't rank them. Some items, such as dictionaries, explanatory memorandums, second reading speeches, are more regularly cited than others. But as we were saying up here, the first step is to just look at the text itself before you go looking at the other things. There's a special note here. One important issue, which is easy to miss, is the question of relevance and value. Extrinsic material is being used to assist, not to come up with a definitive answer. It's assisting the process. It's not defining the answer. The answer in the end will normally come from the words of the section themselves. Which extrinsic material should be excluded? If it was created after the date of the legislation, which expresses a view as to its meaning, it's not generally applicable. Well, I think it's fair to say it's not as applicable as stuff created before the legislation came into being. And the use of delegated legislation to interpret the primary legislation. So what we're saying there is, let's say there is an act. An act might have a number of regulations attaching to it, and then there might also be things like bylaws or planning schemes or accommodation modules, things called other names that might be primary, secondary, tertiary type legislative or material related, delegated legislative material related to the Act. Don't use the delegated legislation to interpret the primary legislation. So here we look at some of these different examples of extrinsic materials. Law Reform Commission reports. In Queensland, we have a Queensland Law Reform Commission. We have an Australian Law Reform Commission, and they mention it here. Explanatory memoranda and second reading speeches. We've mentioned these documents before. They are put out either by the department or by the minister. Obviously, the second reading speech is by the minister, but the explanatory memoranda I'm referring to, and they assist as to what specific sections may or may not mean. In the Queensland legislation, here's an example of an explanatory memorandum, notes on provisions, and then it gives you clause 1, which will be what will become section 1. The bill is the name of the act before it becomes an act. So up until the time when it becomes an act, and the process of becoming an act involves royal assent by the governor, in, say, in the Queensland context. And the different clauses and then what they mean. Second reading speeches, sometimes it's hard to find those even when you're looking in Hansard, because a bill will be debated a number of times. It'll come back to the House maybe over a long period of time. It might go off to a committee of the House. So sometimes it may not be that easy to find where the explanatory memoranda are, but thankfully Now, at least, parliamentary Hansard is on the internet and is quite accessible, whereas in the past it wasn't. You had to go to the actual paper books or the paper Hansard. We've previously looked at the objective nature of parliamentary intention. What we're talking about there is that you need to be very careful to make sure that it's the minister and not individual parliamentarians you're relying upon. Individual parliamentarians, even if they're members of the government as such, or members of the party that controls the House, they may not be articulating the exact views that the minister might be articulating as to the meaning of specific legislation. Parliamentary committee reports. This is something which you see more often at the federal level, and they can be very helpful in terms of scrutinising the bill and tinkering with things in a bill. International treaties and agreements, as I was saying before or earlier, a lot of legislation is based upon a specific convention or a treaty, and it's been passed to enact something which that treaty was seeking to do. The difficulty there is that you need to look still at the words of the act in question and not say, well, the treaty said this, but the act doesn't repeat that specific provision from the treaty, and then look to use the treaty to override the actual meaning in the act. Treaties themselves have their own mechanism for interpretation, which is the Vienna Convention on the Law of Treaties 1974. And so it's a bit like an Acts Interpretation Act for treaties themselves. Legislative history, this is something we've also mentioned earlier in the semester. That is that sometimes when you're looking at a specific act, you need to track back and see where that legislation originated. And I think I mentioned that I recall in the context of maybe native title legislation, tracking back all the way to legislation that I think from recollection in the 1800s was called something like the Aboriginal and Opium Act or something like that, which was the original legislation in that specific field relevant to the circumstances. And so sometimes tracking back in that historical context can provide some assistance in interpreting what the current words were intended to mean. Sometimes words, of course, have been taken across through various acts over time, and sometimes by looking at the earlier acts, working out where that section has come from, it can assist you in interpreting what it means. Other documents, so we're talking there about things like dictionaries, etc., and they've got an image of a dictionary and a thesaurus there. Proliferation and limits. Well, one of the hardest things, I think, has been that whereas, say, 15 years ago or more, it was very difficult to find a lot of this information. Now you can have a complete proliferation of information by virtue of the ability to look for things very quickly on the internet and to find sometimes too much information. I mean, it's not right to say there can be too much, but it's a challenge. And it's a challenge to identify what is the best or the most informative stuff that assists with the interpretation mechanism. So we've gone through the process of looking at extrinsic material. I'm conscious that there has been another recording for this week on your website, but I wanted to do another recording for you.